officially welcome to the de.NBI and GHGA knowledge series, today with Simon Parker, our special guest today, and he's going to talk about how to access data via the GHGA data portal. And the focus this time is the legal roles and the legal rules you need to know for accessing secure data. Before we properly start with the talk, I would like to introduce you the organization. This is a joint webinar organized by, on one hand, by de.NBI and ELIXIR Germany. de.NBI is the German network for bioinformatic infrastructure. It is a large network with diverse institutions across Germany, institutions with about bioinformatic topics and related to bioinformatics. And de.NBI is also the German node for the European initiative, the European platform ELIXIR. And yeah, de.NBI is developing and offering a lot of services for life science, for example, trainings and other events like that, like the webinar, and also they provide the de.NBI Cloud, computer resources for academia in Germany, and they make also as a bridge between academia and industry. And on the other hand, the other organizer is GHGA. That's the acronym for the German Human Genome-Phenome Archive. And we like to say that we are the German secure Omnics data infrastructure. So we provide fair and controlled access to data. And in doing so, we make genomic research easier and more sustainable while ensuring data security. And we are an FDI consortium. We are a federated network of 6 data hubs, and they are coordinated at the KFZ. We are also, we have also international European connections. We are the German node to European initiatives such as the GDI and the Federated European Genome Archive. And well, if you want to know more about GHGA or about de.NBI, you can visit our web pages or also sign up for our newsletter to keep up to date. And now our guest today is Simon Parker. Simon did his PhD in criminology at the University of Greenwich. He was a data steward for GHGA 2 years, and then he moved to the role data protection coordinator for GHGA. And this year, since March this year, he is postdoctoral researcher at BioQuant at the at the University of Heidelberg, the law department. So, Simon, thank you very much for being here.
Yes, thank you everyone for being here. Today I'm going to be talking to you about the legal roles and rules to do accessing data via GHGA. A little bit of an introduction first. So Vanessa's already introduced you to GHGA itself, so I won't go over that again. But of course, operating within Germany, we are subject to the GDPR. And there are a few terms and obligations which reflect how it is that we've set up data access within GHGA. And the first time I want to clarify and explain to people is the role of a controller. So Article 4 of the GDPR defines a controller as a natural or legal person, so a human or an organization, that determines the purposes and means of processing personal data. And so the sorts of questions that come about if we're defining the purposes and means are, why are the data being processed? Under which legal basis is the processing happening? who's going to be involved in the processing, so who are the parties, do we have a processor, or are we doing it ourselves, and how the data will be processed. And they're the sorts of questions that the data controller will define the answers to. Within the context of GHGA, the controller is usually the organization that it submits omics data to be shared via GHGA. Usually there could be circumstances in which a processor submits data to GHGA, but what's really important is that it's the party that controls the data that's remains the controller throughout the process. We also use the term data submitter, and this distinguishes from a data controller in that it's the party that actually performs the submission of data to GHGA. So this could be people who work at the data controller, if the data controller is an institution, or it could be a separate party altogether that is just processing and submitting the data on behalf of the controller. Throughout this talk, I'll tend to refer to the controller, just because we're talking about this in a legal sense. But if I say data submitter, I'm usually mean in an operational sense, the people who are actually performing the submission. We'll come on to talking about data requests as well, and I'll explain a bit more about that. But data requesters would also be considered controllers for the data. Now, the other role that's mentioned in the GDPR is processors, and processors process personal data on behalf of a controller and according to their instructions. And this relationship must be governed by a contract or legal act, and that's according to Article 28 of the GDPR. Within the context of GHGA, then, GHGA is a processor for the controllers that wish to share omics data. Now, there's a slight complication to that. As Vanessa mentioned, GHGA is a consortium project. So we're actually made up of a group of legal entities, and we aren't a legal entity in itself. And that makes it difficult when it comes to signing a contract. And what we've tried to do through our legal structure is really to make it as simple as possible for those controllers that wish to share data. And so in this way, we have DKFZ, which acts as, we term it, GHGA Central. And GHGA Central is the processor. So when you sign a data processing contract, it's with DKFZ acting as GHGA Central. The other data hubs, so Vanessa mentioned we have 6 data hubs, they are sub-processors to the DKFZ. So they are helping DKFZ fulfill its obligations as a processor. Now, within GHGA, we defined 4 different types of data which we process. So we have administrative data, and this is data which is generated by GHGA in order to operate a genome archive. And this would include information about the people who are submitting data and the people who request data. On the most basic level, if you ask us about submitting data, we have your email address and your contact details, but it would also include the information that we use as part of our data security model to identify people when they're acting with regards to the research data. We have non-personal metadata, and we took a very broad view in GHGA of what we included as metadata. And it's essentially any information that describes the research data. Non-personal metadata is primarily used in the GHGA data portal to aid in the discovery of data. So this is information which shouldn't be personal, which helps people decide whether a data set is suitable for their needs. We also include what we would term personal metadata, and this could be something like clinical data or other health-related information. It's not publicly accessible, it's not used for discovery, but it's provided to data requesters alongside the research data to help them understand that research data. And for us, research data is any form of human omics data which we securely store at GHGA in order for it to be shared with data requesters. So again, I'll be talking about these 4 data types throughout this presentation, so hopefully that's clear. Now we'll start by submitting some data, and there are 3 main steps in the submission process for GHGA. So there is a pre-submission inquiry, there's a signing of a data processing contract, and then there's the data preparation and the actual submission. And in this talk, because we're focusing on the legal aspects, I'm only really going to cover the pre-submission inquiry and the data processing contract. The final stage, the data preparation and the data submission, when you come to that stage, you'll be doing so alongside our data stewards, and they'll be able to provide guidance and support in how to do so. So prior to submission, in this pre-submission phase, we ask that if you're interested in sharing research data to GHGA, you make what we term a pre-submission inquiry. And this can be done via a form on the GHGA website. So there's the link there. The reason for doing so is that you'll be asked to provide some information about the data that are to be submitted to GHGA, a description of the study, the types of data that you want to submit, and an approximate size of the data. So you don't need to be exact in there. It's not a case of, if you say you want to submit something that's 100 gig and it turns out it's 101 gigabytes, that'll be a problem. But we more want to understand the scale of the data that's going to be submitted, and we can decide then whether or not we can actually support your submission. And if so, which of our data hubs is best placed to store the data. So one of the sorts of things we would consider here are if your data is already located at an institution which hosts a GHGA data hub, it would make sense for the data to stay there. But we would also consider things such as load balancing to make sure that each data hub is working efficiently. Also, if there are other reasons why a data hub wouldn't necessarily be the best choice in that moment. Once your inquiry has been accepted, you'll be asked to provide some additional information, and we'll use that information to create a bespoke version of our data processing contract. I'm sure one of the questions you'll have is actually whether you can currently submit data to GHGA. So we are working on improving our submission process and to really develop technical tools that make the process as simple and as straightforward as possible. As they're in development at the moment, we are accepting submissions, but there may be some delay as to when we can actually do so because some of the work that's going on behind the scenes. So what we would say is we encourage you to make a pre-submission inquiry if you're interested, and then we'll discuss with you whether we can accept the submission or there's the sort of time frame as to when we would be able to process that. So the data processing contract, as mentioned, one of the requirements under the GDPR is that there is a contract or legal act that exists between a controller and a processor. And since GHGA is acting as a processor in this relationship, we require the signing of a data processing contract in order to actually submit data to GHGA. The DPC is in sort of two parts by and large. The main text describes the services that will be provided, and these align with our terms of use, which again you can find online, and there's a link. All the links will be provided at the end and also in the chat as well. And so this talks about, the fact that we'll be taking in the research data and the personal metadata, the obligations regarding the non-personal metadata, how you can terminate the contract should you wish, and all those sorts of those aspects. Then we have a number of annexes to the contract, and these focus mainly on the data protection relevant information. And I'll explain a bit more about that on the next slide. We do provide a template version of our data processing contract online, so you can go and have a look at this. You can go and take that to your legal departments or whomever's responsible for signing contracts at your institution, and they can have a look over the terms and ask questions about them, things like that. However, at this stage, well, not at this stage, but we would ask that you don't fill in the data processing contract and send it to us. The way we would work is we collect the information from you as part of the pre-submission inquiry, and we produce a sort of bespoke version of the contract, which has all the information that needs to be filled in added to it, and that way you get a version of the contract which is finalized. Now, the contract does set out a few obligations towards the controllers, just to sort of explain what they might be. So the first one is that by signing the contract, then you, as a controller, are stating that there is an appropriate legal basis for the sharing to take place. So you are responsible for sharing personal data with us, the research data, the personal metadata, both forms of special category personal data, and you're responsible for having a legal basis that allows you to do so. So most submissions to GHGA are done with consent being the legal basis, but you should check that actually the consent allows you to do so, or if you're not using consent, that the legal basis allows you to do so. In the event that there is an issue with the legal basis that's been shared, of course, this would come back to the responsibility of the controller and not GHGA. You must remain contactable whilst the data are stored at GHGA. So GHGA acts under the instructions of the controller, and we need to be able to contact you in order to get those instructions. One of the things is with GHGA is we're a platform that facilitates controllers to share data with secondary users. We're not just a place where omics data can be dumped and forgotten about. And so it's really important that you remain contactable whilst the data is stored at GHGA. You should submit the research data in a suitable and commonly used format. A vast majority of studies are submitted as FASTQ files or BAM files. We can support other formats, but this is something that you'll discuss with the data steward when you in the submission process. Non-personal metadata must be submitted in accordance with our metadata model. So GHGA has developed a metadata model. This was a significant piece of work for us because obviously we want to make a model which is both useful when it comes to data discovery, but also considers the data protection aspects of actually sharing metadata, which could, in some cases, lead to the re-identification of data subjects. And so we have a kind of model which we've designed around those things and also to make sure it's interoperable with other international standards. Again, this is something, there's information online about a metadata model, and you can speak to our data stewards and they can help you on that process. The research data and the personal metadata that you submit to GHGA must in principle be available for data requesters to access. We're not saying that you have to accept every request that comes in, but in principle, it should be available to data requesters who are suitable to take those on. GHGA as a processor has no role in assessing access requests. So we don't take decisions on who may access the data that you submit. That's something that the data controller has to do. And finally, you must respond to data subjects' rights requests. So the GDPR sets out a number of rights that data subjects have. Articles 12 to 23 off the top of my head. These might include things such as the right to have the data deleted, say if it's been collected under consent and they withdraw their consent. Because the data we receive is pseudonymized, there's no way for GHGA to act upon that. And so we would rely on instructions from the data controller in order to fulfill those rights requests. And so if they come in, that's something that the controllers are responsible for dealing with. Now, I mentioned that the annexes deal with the data protection aspects of the agreement of the annexes to the DPC. And so in Annex 1, you'll be required to list all the data that's going to be submitted under that agreement. And what this means is you can submit multiple studies or multiple projects under a single data processing contract, but you can't submit data which isn't covered in one of those studies. So that way we have a control as to the information that's coming into GHGA. Under Annex 2, we list all the data hubs because these may be acting as sub-processors. Generally speaking, the data controllers aren't necessarily told exactly which data hub the data will be going to, and there may be needs for us to have the data split across multiple data hubs or to have backups in one data hub and the data stored in another. And so we list all the sub-processors who would be involved. Annex 3 describes a controller to processor relationship between the controller and the DKFZ. So this aligns with Article 28 of the GDPR. And the terms that we have in the Annex 3 are very much based on the EU standard contractual clauses for these types of relationships. There are one or two small tweaks which we highlight and make clear to you, but hopefully, because they're based on these standard contractual clauses, it would make it easier when it comes to reviews by your legal departments because they'll be familiar with these terms. Annex 4 lists the persons who are authorized to act, and I'm going to explain a bit more about what that means. Annex 5 covers the sharing of non-personal metadata, so the controller is responsible for making sure that the metadata they submit is non-personal within the meaning of Article 4 and Recital 26. Nothing in the metadata model requires the submission of data which is personal, but of course, there are ways in which personal data or data could be interpreted as being personal based on the metadata. And Annex 6, we describe the processing of your administrative data when you are submitting data to GHGA. So we need to process data about the controller and data about the people who are authorized to act by GHGA, and your rights and information about that processing is described in Annex 6. One thing we have tried to do within GHGA is really to think quite holistically about the data that we process. So it's not just about the research data, but we also think about the metadata. We also think about the data protection when it comes to your personal data as a customer of GHGA. Now, one of the challenges that we've seen for projects that are interested in submitting data is actually thinking about who signs the data processing contract. So, as mentioned, it's signed by the controller and the EKFZ in their role as GHGA Central. The controllers are usually represented by a senior figure within the institution. So, in most cases, the controller is an institution and they're represented, say, as by the head of the institute, or a member of the management board, etc., or perhaps a representative from the legal team. I'd say it's not usual for a PI to be permitted to sign a data processing contract on behalf of an institution on their own. Of course, each controller is free to define who's permitted to sign a contract. It's just not that common that it's the PI on their own. And so, when we've had discussions with data submitters and we see a data processing contract that's signed by a PI, we would normally come back and say, is actually the PI the right person to sign this within your institution's kind of framework, or does it need to be someone with perhaps more senior role? Now, one of the challenges that projects face is that many projects are collaborations involving multiple parties. So you might have one institution collecting the data, say a hospital, you may have another research institution doing the sequencing. And so it can be somewhat unclear as to who the controller is in those circumstances. And so what we really advise is that you look into this before making a pre-submission inquiry. It's one of the areas which the process of actually submitting data to GHGA is most often held up. And that's working out who the controller is once the process has kind of already started, or it becomes apparent through the process that it's not clear who the controller is, and actually getting then the contract signed. And so if we think back to the definition of a controller, it might be useful to sort of think of those questions around who's taking the decision on what we're doing, who's doing it, and why we're doing it. And that will probably lead you to sort of reveal the identity of who the controller is. It may also be useful to look at any kind of agreements that exist within the project between the parties that actually describe the roles in which each party is operating. In circumstances which there are joint controllers, so the GDPR allows there for joint controllers if multiple parties have together defined the means and purposes of the processing, it's usually sufficient for a single controller to sign the DPC on behalf of the others. So we don't need to have, if you've got 20 joint controllers, we don't need to have all 20 parties sign the DPC. One is usually sufficient, unless it sort of seems like maybe the controller isn't approved by the other joint controllers to do so. One is normally sufficient for signing the DPC. Now, I'm just going to take a quick diversion to speak about the DKFZ. So I'm sure there are some people here who are based at DKFZ. And it isn't possible for projects basically, Keir said, to use the standard DPC for submissions. And this is because, of course, DKZ would then be signing it as a controller and as the processor, and it doesn't really make sense to sign a contract with yourself. Instead, if you're based at DKZ, you can use a document that's titled the DKZ Internal Terms of Use for the GHGA Data Infrastructure. Very clever title there. And it sort of explains really what it is. It's a terms of use around the use of the GHGA infrastructure for those projects. This can be found along with further instructions on how you go about the process on the ODCF website. So there's a link there. So if you're having your data processed within the ODCF, there is, we work quite closely together, and so hopefully that would be a fairly painless process for you. The terms of use can be signed by the responsible PI, and they have been approved by stakeholders within the DKFZ to be used for this purpose. So this isn't just something we're putting out there. It has been approved, so you don't need to worry about going to get them approved again. In circumstances where DKFZ is a joint controller, it's generally preferred that one of the other joint controllers agrees to the standard DPC rather than relying on the internal terms of use, just because they have a bit more of a rigid kind of legal foundation than the terms of use do. I mentioned persons authorized to act, and this can be something a slightly confusing idea. So hopefully we'll clarify it now. Now, as a processor, GHGA only acts under the instruction of the controllers. So we don't do things that we're not told to do. The controllers either tell us through the contract or they tell us by direct instructions. But since controllers are typically institutions, GHGA needs to know who the natural people are that will actually be issuing the instructions. For example, it wouldn't be terribly efficient to say, well, the DPC is signed by the head of the institution, therefore we would only accept instructions from that person about the processing that we would do. But at the same time, it wouldn't make sense for us to say we will accept instructions that we receive from anyone with an email address linked to that institution. And so what we're trying to do is strike a balance between being very rigid, and also being sort of data protective. And we refer to these people, these natural persons, as persons authorized to act because they are authorized by the controller to act on their behalf. GHGA will only follow instructions expressed by persons authorized to act. So we won't just accept, if someone emails us and says, oh, my institution has this data here, we'd like you to do this, if they're not on the list of people who are authorized to act by that institution. So within the data processing contract in Annex 4, you can list people who are going to be authorized to act. It's up to you how many people you list. I would suggest 3 to 5 is a reasonable number. You need it to be enough that it's flexible in the event, people are on holiday or they leave or things like that. But you don't want too many because then that becomes a bit of a data security problem in terms of managing who's actually issuing instructions. In order to be authorized to act, they need to provide a life science login ID and an independent verification address, IVA, and I'll explain an IVA a bit further on. But these again are around making sure that when GHGA is receiving instructions or speaking to people, that we can be certain we're speaking to the right people and the people who are actually verified and we know who they are. We hope that projects will be able to, when they submit data, they'll store it and share it via GHGA for a long time. And of course, there maybe needs to change who the persons authorized to act are, and this can be done. So a person who is authorized to act can contact us and say, we need to add on some additional people, or we need to remove some people. And we have a process for doing so. So it's not a problem if that changes. We expect it to change, in fact. In addition, in the event that all the people authorized to act suddenly, resigned en masse, or there was some terrible disaster in the sequencing center, the person authorized to act would default back to, say, the management board of the institution or the DPO. So we shouldn't have a situation whereby there's suddenly nobody who's authorized to act. But we think it's good to have a few people who can issue instructions who are sort of closer to the data. A couple of data protection obligations, just to highlight to you if you're interested in submitting data to GHGA, is of course the legal basis. And the legal basis are the lawful justifications of the processing of personal data. And what's really important is the controller has a legal basis that allows you to submit data, so the research data and personal metadata to GHGA, and for it to be then shared with data requesters. But this is something that you, as a controller, would be responsible for. We also advise around records of processing activities. So Article 30 of the GDPR requires controllers and processors to record any processing of personal data they perform. There are a couple of caveats, hence the asterisk, but in the circumstances of submitting data to GHGA, they're very unlikely to apply. You probably will need a ROPA. And so, again, for good practice, we advise that you check whether the submission of research data and personal metadata to GHGA is described in the ROPA. We don't check this, of course, it's up to you, but it's just something to flag to be aware of. And finally, on those points, data protection impact assessments, so-called DPIAs, this is an obligation of controllers when the processing of personal data is likely to result in a high risk to the rights and freedoms of data subjects. An example of this could be processing large volumes of special category personal data, such as a large study involving genomic data. So you may need to perform a DPIA according to Article 35. Now, GHGA has performed some of this work internally. So we have performed a risk assessment where we looked at the things that could go wrong when you submit data to GHGA all the way through to when we share it or when it's destroyed at the end of a contract. And you can incorporate this information into a DPIA if it's decided by your institution that you need to do one. So there'll be other risks that you need to consider about what happens before it comes to GHGA, but we've performed a risk assessment, we've written a report, we can make those available to you upon request. Now, data access requests, the other side of it, there are also some legal roles and rules that apply. And the four main access steps are making a data access request, the decisions in the contracts, and the release of the data and the data download. So I'm going to be touching on the first three parts here. When it comes to something like the decision and the contracts, this is very much the responsibility of the controller. So the slides that I will present here that deal with those matters, they are either advice from GHGA. We have done some work in this area and provided some guidance that controllers are free to use if they want to, or my own opinions of how I would address this challenge if I were a data controller. So we don't instruct you to do things in any particular way, but of course we want to provide some advice to help you if you're unfamiliar with doing this. In terms of making a request, you would be browsing for data in the GHGA data portal, and you can then make a request from there. You must be signed in as a registered user of the GHGA data portal in order to make a request, so that we make sure that you're legitimate. And the way you would do so is, here's a kind of snapshot of some metadata for a study that we have. You would click simply on the request access button there, helpfully pointed to by the orange arrow. And then you would be asked to provide some information about the request via a data access request form. So this is a pop-up that comes up. You would be asked to explain why you'd like access to the research data, how long you would like access to, so a date that it starts, a date that it would end, and a contact email address. And this information is then sent to the controller to be reviewed. And it looks something like this. So you would say, I need access for research, the research that you're doing, how you're planning to actually use the data, where you're based, things like that, and a contact email address. And that would then go off to the data controller to be reviewed. Now, as mentioned, GHGA doesn't have any kind of role in how access requests are reviewed. It's entirely up to the data controller. Many data controllers, though, rely on data access committees to support the review of data access requests. And the way this works is that a controller when they sign a DPC, they have to provide a means by which data requesters can contact them in order to make an access request. So they would provide an email address, and when those data access request forms are filled in by a data requester, those access forms are then sent to that email address. So one thing to bear in mind is that the information is displayed within the non-personal metadata as well on the GHGA data portal. And on that point, we would really advise that you don't just include your own email address as, the scientist who's responsible for the data. Partly because, it's non-personal metadata, and of course your email address is personal. But also practically, people change roles, they change jobs and things like this. And what we don't want a situation is that the only way of contacting someone about an access request goes to an email address which is now dead. And so what we advise is that you have, say, dac@institution.de kind of email address or something like that, which is non-personal, which multiple people can access, and it becomes more of a long-term way that people can request access to you. You can have the request go directly to your DAC members or an intermediary, like a data steward, who can pass it on to the DAC. It's entirely up to you how you define that process. What we would advise, though, is that you define the access process prior to submitting the research data and personal data metadata to be shared via GHGA. It may be that your study is instantly popular and you start receiving lots of access requests. So it's really good to have the process thought out prior to submitting the data, to think about who needs to be involved in the process, the actual practicalities, how are you going to make it in an operational sense, all those sorts of questions. So think about those before you submit the data. And if you're using a DAC, or once a decision regarding an access request has been made, like positively or negatively, a person who's authorized to act must communicate the outcome to GHGA. Again, we only follow instructions from people who are authorized to act, and the instruction to share the data with someone obviously needs to come from someone who's authorized to act, because it's sensitive data, and we don't want to just send it out to anyone because we received an email from someone saying we should do so. Now, in terms of DACs, so these slides are really going to be about advice and guidance. You're free to take it up or ignore it, and some of it is my own opinion as well. You're free to define how your DAC operates, whether you have a DAC at all. What we did within GHGA is develop some guidance for controllers on how to set up a DAC. So if you look at docs.ghga.de, and that's where we that's where we publish a lot of our documentation for users. One of our user stories talks about data requests and data access. And we have some guidelines around DACs in terms of things like having terms of reference and how you can actually operationalize those processes. If you don't have something already at your institution and you're looking to set something up, that can be a really useful place to start. So my own view, if I was setting up a DAC, would be around, who are going to be the members of that. I would probably have someone with the experience of the data in question, such as a data steward who's been responsible for the data. They will have a good idea around the risks and what can actually be achieved with the data because they've been hands-on with it. I would also include someone who has internal responsibility for the data, such as the PI, who may be able to have an understanding as to whether the use that's been requested is appropriate or whether they see problems with it. I would have someone who has some responsibility for legal matters, because ultimately you'll need some sort of legal agreement with the data requester. I'll explain a bit more about that on the next slide. And so someone with familiarity of those things is usually a good idea, and someone with responsibility for data protection as well. Again, this is just my views. You're free to define these however you wish. But I think it's good to have a kind of breadth of knowledge, not just people who know about the data, not just people who know about, say, the legal or data protection matters, but to actually sort of combine those experiences to come to good decisions. DACs could also be an opportunity for data subjects to contribute to the decision making within the project. So at GHGA, we conducted the Pagoda study, and this looked at patient involvement in the governance of omics data And what we found there was that access requests and decisions on sharing data were an area where many patients and data subjects saw that they could have a positive influence on research, and an area where they felt they could be involved. And so perhaps that could be something that you think about as well when you're defining who's going to be part of your DAC. In terms of reviewing requests, again, this is my view on the things that I would consider. I would think about, is the data requester a legitimate researcher based at a bona fide institution? Is it a real research institution that's requesting its data? Is it something which looks maybe not legitimate, or someone who doesn't really seem to have a background in research? And this is for a couple of reasons, and some of those I will explain now. And again, to think about, is the actual access to research data and personal metadata necessary to achieve the aims of the project? So under the GDPR and Article 5, there are a number of principles around the processing of personal data. And one of those is to really think about, is it necessary to process personal data to achieve the aims of the processing? And so it's important to actually consider, this project, does it actually need this data to achieve that, or could it be achieved using non-personal data, for example? And if so, then it really should be done so according to the principles of the GDPR. You think about whether the project is likely to lead to negative consequences for the data subjects. So, are the researchers who are requesting access doing so because they want to do something which is like beneficial to the data subjects or people in similar positions? Is it about trying to develop a new treatment for a particular condition that's likely to be beneficial to the data subjects, or at least people like the data subjects? But equally, if it was about accessing the data in order to target particular groups of people with adverts, or in some form of kind of discrimination, that's probably not going to be a good use for that data, or an appropriate use for that data. And again, that feeds back to the principles of the GDPR around data processing should be fair for the data subjects. Now, thinking about the necessariness and the legitimacy of the researcher, it's important to consider whether a project has a reasonable chance of success. Whenever we process personal data, there is a risk to the data subjects. They could be re-identified, or some other harm could come to them. And so if we're saying that the processing is necessary to achieve the project's aims, we need to think about whether it's realistic that the project will actually achieve those aims. And partly this will be based on the science, hence wanting to have people with an understanding of the data involved in making decisions. Is this project actually feasible based on what we know at the moment, or with the data that they're asking for? But also, does the researcher have the skills and the experience to actually achieve what they're setting out to do? And if there's doubt around this, and actually we don't think it's likely to be to succeed, we have to start thinking, actually, then the risks that could come about for the data subjects outweigh the likely success of this project. And if there are greater risks than there is the likelihood of success, then maybe we should think whether or not this is an appropriate use for that data. Also, in a kind of practical sense, are the research data and personal metadata to be transferred to a third country or an international organization? So transfers within the EU and EEA under the GDPR are relatively straightforward. But if you're going to transfer the data to a third country, so a country outside of the EU or EEA, you need to think about what mechanism that transfer will be undertaken. So the GDPR allows, for example, transfers to countries where there is an adequacy decision. So the country has a level of data protection which is equivalent to the GDPR, or at least approved by the European Commission as such. You may need to use standard contractual clauses if that isn't the case, but you need to think about what mechanism the transfer is to take place. It's not usually just the case that you can simply transfer the data outside of the EU. So just a flag, if you're particularly thinking of, say, transferring data to projects based in the US, there is a kind of limited adequacy decision under the privacy framework, but only certain organizations are included under that. And so you may need to think about a different mechanism if the partner you're transferring to is not one of those international organizations. If you're transferring to the UK, there is an adequacy decision, so that potentially becomes a mechanism by which you can perform that transfer. Now, once a decision has been made on access, or a positive decision has been made on access, you're likely to want to set up a data transfer agreement. And data requesters are considered to be controllers, and this is because they are deciding upon the purposes and means of the processing that they're going to do. So they've designed a project, and their purposes and means have been designed within or defined within the scope of that project. So they're distinct from the project in which you initially collected the data, and so they're likely to be considered controllers then. So you wouldn't have something like a data processing contract because they're not processing the data under your instruction, but they've defined their own purposes and means. Now, the GDPR is quite vague on these relationships. I don't think it mentions controller to controller anywhere within the text, either in the articles or the recitals. And many institutions, therefore, use a data transfer agreement or similar legal device. It may be called like a data access agreement or something like that to sort of define the relationship between two controllers. So the GDPR talks a lot about controller to processor. It talks a little bit about joint controllers, but it doesn't really talk about controllers to controllers. And again, my suggestion for the sorts of contents that you would have within such a DTA would be, of course, defining the parties that are going to be involved. So, the controller and the controller that's requesting the data, the reasons why the data are being shared, the legal basis for the sharing, the specific data items that will be shared. So, if it's not the whole data set or if it's data for a particular project, of course, you wouldn't necessarily just say we're going to share all the data that we have at our institution with another institution. If there are any specific purpose limitations, and these could be tied back to the legal basis. So, for example, if you're processing under consent, it may be that the consent states that the data will be used for certain purposes and not others. And so, of course, that limitation would then apply to the data controller, the data requester. It may also be that you say define a limitation to say that they're only allowed to process the data for this particular project that they defined, and not just as a kind of general, we're transferring the data and you can process it for whatever purpose. To think about how data subject rights requests will be handled. So a data subject could make a rights request to a data controller, and it may be that you need to interact with each other in order to address those requests. And also, again, to go back to the point about if data being shared internationally, if that is the case, the DTA should really include what that mechanism that's being used for this to take place is. It's important to define that to make sure that it's actually appropriate for the purpose. I mentioned IVAs, and so I'm just going to talk briefly about those. An IVA is a term we use within GHGA as an independent verification address. And it's an alternative contact method used to verify personal accounts. Typically, this is something like a phone number that we then use to send like an access code to or something of that nature. And they're an important part of GHGA's data security model. So I mentioned earlier we did a risk assessment for GHGA, and one of the areas that we felt our potential vulnerabilities when in such a data archive is around actually making sure that when we're being instructed to do something, we know that the people who are instructing us are the right people, the people who have been approved to do so, but also when we share data, that we're sharing data with the right people, that we're not just sending it off to anybody. And so the IVA helps us do this by making sure that we have these two factors, ways of actually authenticating and verifying people. And within our data processing model, we use IVAs in sort of three areas. And these are data submission. So if you're going to be, if you're a person authorized to act, you need to have a verified IVA so that, we make sure we're receiving data from the right people. If you're going to download data, you can register you only need to be a registered user in order to make an access request, but you can't actually download the data until you have a verified IVA. And during the negotiations between a controller and a data requester, the data controller should also verify the IVA of the data requester, so that when they notify us that an access request has been accepted or approved, we make sure that we both know that we're talking to the right people, that we're using the same IVAs and IDs and things like that. So again, this is about making sure that when we go to make the data accessible, we have actually done it made it accessible to the right people. Okay, so that was everything I wanted to present about the legal rules and rules and access requests and things like that within GHGA from a legal side. I mentioned a few links, so these are provided on the screen here if you need to jot them down, and I think they'll be in the chat as well. So, of course, you can pop to GHGA our main website. You can also contact us there if you're interested in downloading the contract and taking a look at the terms. The link's there. Our terms of use are available on Zenodo. Our user docs are quite extensive. They have a number of different user stories that you can follow through that talk you through the steps, and including things around how to make a pre-submission inquiry, how to sign a data processing contract, and how to submit data. So each of those steps is covered. If you just want to make a pre-submission inquiry, you can do so. There's a form that you can fill out on our website. And if you're based at EKFZ, again, have a look at the ODCF documentation, and that will provide some guidance to you. So that was it from me. I'm happy to answer some questions if we have time.
Yeah, thank you. Thank you to you, Simon, and thank you to our audiences for the interest and to be here. And thank you also the organization and my colleagues, Julia, and the others involved in the webinar series. Have a nice day, everybody.